Hello, everyone. I'm Haley Hansen. I'm the leader of Husch Blackwell's Higher Education group, and we welcome you today to our webinar, The Clery Act, Common Violations, VAWA Requirements, and Compliance Tips. Before we get started, I would like to cover a few housekeeping matters. At the bottom of your audience console, there are multiple applications for your use during the program today. First, if you have any questions during the webinar, please submit any questions via the question box. We will try to get to the questions, but I'm going to be honest, we have 75 slides today and 60 minutes, so the likelihood of us getting to the questions is not high, and anyone who's attended a webinar with me before knows I like to talk, so it is not high, but we will do our best if we can. If we run out of time, though, we'll try to get back to you via email regarding your questions as well. Also, there's a PDF of the presentation. It is available in the icon that says Program Materials folder. It looks like a little folder. The program has also been approved for continuing legal education hours. And for live attendees, you report your hours by clicking on the CEU icon at the bottom of the screen. You'll also receive a certificate of attendance that will include the course number. It will be emailed to you along with the recording of the webinar, and you're welcome to watch the webinar again if you had to leave earlier, or share it with colleagues at your institution again as well. Towards the end of the program, we'd also ask you to complete a short survey. It's very important that we get some feedback, and also we use those surveys for future programs. So, well, all the housekeeping matters are done, so let's go ahead and get started. So I'm Haley Hansen, as I introduced myself before earlier. With me, I have two great colleagues. I have Ellen Armentrout, and Ellen's practice involves working on various compliance issues, and she works a lot on Clery issues. She also works with Title IX and VAWA and advises clients regarding public records requests, policy development, accreditation standards, and all other types of governance documents that schools ask us to review. Peter Anderson is also with us today, and he works with our group and assists us in matters involving policy compliance. Peter has done a lot of work regarding the Clery Act and has also done a lot of work regarding the Violence Against Women Act. So we're very happy to have both of them today to talk to us about Clery matters as well. And Peter has also helped with a variety of investigations and transactions at the firm as well. So happy to have both Peter and Ellen with us today. So we always have our standard legal disclaimer. You know, it wouldn't be lawyers if we didn't give you a disclaimer, right? This presentation is not intended to be legal advice. We are giving you general information. And as we're talking through information, some of you are our clients, some of you may not be. If you actually need a question that you need legal advice for, please reach out to your client contact separately. Okay, so here's our agenda today. So first, we're going to cover a little bit of background, and I do just kind of caution everyone, it looks like we have close to 600 participants today. We have a lot of people that are new to Clery, so we are going to go over a little bit of background that may seem pretty elementary to some of you who work in Clery all the time, but we'll get to the meat, don't worry. We're also going to talk about common Clery violations and give you some compliance tips. And then we're going to do a little bit more of a deep dive into VAWA compliance, because it is one of the areas when we review annual security reports, it's one of the areas that we see a lot of compliance issues with. And then again, if we have time, we'll try to get to questions as well. So the brief Clery Act background, this is Janine Clery, who was raped and murdered in her dorm room at Lehigh University in 1986. And her parents went on a campaign to make schools safer. And so as we talk about the Clery Act, we're really referring to a group of laws. The first was enacted in 1990. And one of the most important things, I think, about these laws are that they always have had bipartisan support. I'm not sure there's a lot of things within our politics right now that we can say have always had a lot of bipartisan support. But the Campus Crime and Security Act, how it was originally enacted, and now what is known to be the Clery Act, has always had bipartisan support. So as you can see, there's been numerous amendments, and actually the name of the act was changed in 2008 to be the Clery Act itself. The most recent amendments in 2013, which then, due to the regulations, went into effect in 2015 regarding the VAWA crimes, people still really struggle with. So we're going to go over those as well as we talk through that today. I think it's also important to note, and I'm sorry I went over this a little quickly, that there's been some movement within the Senate specifically to have additional legislation regarding Clery. And the Restoring Civility on Campus Act has been introduced, and it would ensure that universities and the Department of Education immediately address civil rights complaints if a student experiences violence or harassment on campus because of their heritage. Again, it's just been proposed very recently, but it may, and it may not actually make it even out of the Senate, but I think it's important to know that this is something that our legislature is still really looking at. The most one of the interesting parts of this proposal, though, is that it would actually increase fines and your annual security report from currently it's $69,733 per violation, and it could raise that fine, especially for crimes motivated by anti-Semitism, to $1 million per violation. So again, increasing those crimes, those fines pretty significantly as we look at the response to, I think, political issues and also protests that have happened recently on campuses. So we have the laws, as we've talked about. There's also sub-regulatory guidance. And let me just tell you where we stand with sub-regulatory guidance right now. Now, what do I mean by sub-regulatory guidance? So the law is enacted, and then the Department of Education is tasked with putting forth regulations, which typically the notice and comment and rulemaking process for new regulations takes on average about 2.5 to 3 years for new rules to take effect. Once they have taken effect, assuming that they haven't been challenged in court, like we've seen the new Title IX regulations, they have the force and effect of law. And unless there's an act of Congress or the department actually goes and changes those regulations, they cannot be withdrawn by a change in presidency. So that is regulatory, the regulatory process. Sub-regulatory guidance is really just guidance by the department. And so the main guidance had been the Clery Handbook, which, as you all know, has been rescinded. And then we have seen the appendix, the FSA appendix, take its place, which was very short and concise. And then you also have findings letters. And the department used to publish all of its findings letters from its final program determinations online, and has kind of stopped doing that during COVID. And we've only seen one that's really been published within the last 12 months. So those are areas of sub-regulatory guidance. Sub-regulatory guidance is the standard by which the department will enforce the law. It is not the law itself. So I think that's important. It doesn't have the full effect of an actual law. All right. So which institutions must comply with Clery? All institutions participate in Title IV programs, including if you have any foreign campuses. Distance-only schools and foreign institutions are not subject to the Clery Act. So we've gotten to our first poll question today, and this is kind of a common mistake, so we're going to ask you this today. Which of the following is not explicitly required by the Clery Act and its implementing regulations? A, publishing an annual security report by October 1st of each year. B, providing campus security authority training. C, providing programming regarding the Violence Against Women Act. Or D, including statistics for certain crimes committed on public property surrounding the campus. So we'll let all of you vote. See, I think, and then I'll show you the response. right, hopefully most of you have voted. Yeah, we've got about 200 out of the 600 of you, so let's see. All right, we're getting close to half, so I'll go ahead and show you the next slide. All right, so the correct answer is provide campus security authority training. And so we started with the hard one. No, we know that. But that is the correct answer. You are required to provide programming regarding the Violence Against Women Act, and Peter's going to talk about that a little bit more as we go forward. All right, so what do we see are common violations and compliance tips when we talk about Clery? When we talk about these, campus security authorities seems to be a big one. And when you actually, we haven't seen a lot of program or final program review reports recently, but in the ones that we saw leading up to COVID, there were lots of issues regarding campus security authorities. And so I think it's important to understand what is a CSA. So a campus security authority is a campus police department, any individual or individuals who have the responsibility for campus security, but don't constitute a campus police department. And then also you have individuals, I got a little bit ahead of myself, sorry, but you have other individuals that are, again, responsible for reporting information that they are responsible for security at the institution. The obligations of a CSA are to make sure that the institution reports information within their ASRs and the information is properly reported in their daily crime logs, Clery crimes within Clery geography that's reported to police or CSAs. And so those are some of the obligations. So one of the big things that we think is a common compliance area is the fact that how do you identify CSAs? And as we've seen, a lot of institutions, they've faltered regarding CSAs. So we used to be in a time in which we had like 5 CSAs on a campus of 15,000, and that doesn't really make sense. And then we went to where we had a lot of CSAs, and I think now schools are trying to find a middle of how do you evaluate CSAs and how do you make sure that if you identified someone as a CSA, that CSA, number one, knows that they're a CSA. We've actually had a Clery audit in which a CSA was interviewed and they didn't understand that they were a CSA. And as you can imagine, that didn't necessarily go well for the institution, but knows what their responsibilities are as well. So the FSA handbook actually says that the department will defer to the institution's designations of CSAs as authoritative. So that's good, but on a case-by-case basis, you have to actually make determinations as to whether the individual is going to be a CSA, and you should focus on, in making these determinations, whether they have significant responsibilities, and whether or not they for reporting those crimes and what those significant responsibilities are. So one of the most important things that I think we tell our clients in determining CSAs is, number one, you should have an individual who is working on identifying who are your CSAs, keeping track of those CSAs, and then making sure that you have documentation as to why you made some of these determinations as to who is a CSA. So some common mistakes we see are failure to identify relevant employees as CSAs, failure to inform the individual that they are actually a CSA, failure to train the individual regarding CSAs, and failure to keep track of new and departing CSA positions. So we see that quite a bit as well. So what are some compliance tips for you? Again, focus on that regulation language to maintain this current list of who you're identifying as CSAs. When new positions are added, determine if they should be CSAs. Have a process by which those positions are added. And again, you've got to make sure that CSAs understand what their role is and what they are not supposed to do. They are supposed to report. They are not ever supposed to be, as a CSA itself, the investigator itself, unless they're part of the police and that they have other responsibilities for investigating. So it's going to be really important to do that. So again, as we said earlier in the poll question, it's not required to provide annual training. However, and this has been one of the most difficult compliance areas that we've seen from the department will acknowledge that it's not required to provide CSA training, but then in program review determination letters say you really can't be in compliance unless you do some sort of training. So getting lots of different information, these are multiple letters that have really criticized institutions for failing to provide that training. So consider whether or not you want to do some CSA training. It doesn't have to be, when I've talked to other clients, they think, oh, do you have to do an hour-long training regarding what it is to be a CSA? No, you don't have to do that, but you do have to give the relevant information. And trying to create standardized reporting forms can really help. So explaining what they need to report, what that individual, who they actually report that to, and what the report looks like is really important as well. It's also important for you as an institution to make sure you're sending out requests to CSAs at least annually. In fact, in one review, I had the department reviewers say it should be twice a year, that you send out emails or notifications to CSAs to ensure that they've complied. Have you made sure that you've reported everything that you need to report in your capacity as a CSA? The other thing that we've seen that's really been helpful is potentially having a policy regarding CSAs. And, you know, I think understanding as you look at the CSA's policy, what are the repercussions or consequences if they are not in compliance? And so an example would be, let's say that you have a residence hall director that should have reported something as a CSA, and they're clearly a CSA. Maybe not train them, but given them information that they're a CSA. What is the response of the school if they don't report? Is it that they can no longer serve in that capacity? And a lot of times we have student employees that are serving in capacities which end up to be CSA positions. So thinking about that as well, because that can be a big compliance issue, as well as if you have CSAs who have not reported and then are still serving in that same capacity. Okay, so let's move on to what we think is really another big area of compliance mishaps and mistakes, and that is Clery geography. And it's interesting because when we talk about Clery geography, I mean, most of you understand the nuts and bolts of Clery geography, but when you actually talk about Clery geography, it can be very confusing for a lot of people. So let's talk about this first poll question. So ABC University leases a classroom in a building owned by the local psychology practice, which is 1.2 miles away from ABC's main campus. Students from ABC's psychology program take one class in a classroom and shadow providers throughout the building. Some of the providers are also university faculty members. ABC has identified the building as a separate campus. So is this correct? So the answers are no, the building is not a separate campus, but the classroom is. Yes, the entire building is a separate campus. No, the building is not a separate classroom. But it's not a separate campus, but the classroom is non-campus property, or I recommend that my institution simply not engage in these arrangements because they're too confusing for Clery. Some of you might want to put D. It's not the right answer, but we can understand it. All right, so I've got a few of you. I've only got about 10% responding so far. Give you just a few more minutes. I know this one is tough. We've got almost half now that are coming back to us. All right, so let's show you the results. So again, it's going to be a very fact-intensive analysis, but 62% of you got it right. So that is wonderful. So this is not going to qualify as a separate campus. And I think that can be very tricky. And the reason that it doesn't qualify as a separate campus is that ABC University is only leasing a classroom. So now you have to look at, does the classroom itself qualify as a separate campus? And because it's just a classroom and there is no administrator on site, you don't meet all the requirements for a separate campus. And so it would be considered non-campus property. And why is it considered non-campus property? Again, ABC University leases that classroom, so you have control in the classroom. It is frequented by students. It's not reasonably contiguous to your main campus. And so therefore, again, 62% of you came up with the right answer. But again, these can be really tricky and very fact intensive. And what's really important, especially when you get into one that's a little more of a gray area than maybe this example that we gave to you, is to document your analysis as to what you were thinking when you determined to classify this classroom as non-campus property. And that is going to be so helpful for you if you get a Clery audit, because they really want to see what was the thought process that you went through to make sure that you classified this correctly. So we understand Clery geography generally. I think some of the things I really want to hit on in this webinar that are common mistakes are that there seems to be, and I don't say this lightly, but there seem to be some sort of silos when it comes to Clery at times. And so not a lot of people are looking at geography questions or understanding geography. This is a multidisciplinary responsibility that you just can't have your chief of police or their designee or one individual within the security department be responsible for. Because if you do, you're likely not going to get your geography right. If your geography is wrong, as you can imagine, your ASR is going to be wrong because you're not reporting on the correct geography. So again, on-campus property is usually pretty easy, part of the institution's campus. Non-campus property, buildings, we'll talk about just a little bit more, and public property that's within or immediately adjacent to the campus itself. And then for purposes of the daily crime log, your patrol jurisdiction is what the area upon which your campus police or security are patrolling. So I'm going to go through these pretty quickly. So, and they're in your slides, so you're welcome to use them. But again, just definitions of campus. I think one of the examples here with the second bullet point is just like a bookstore or cafe that's owned by the institution but rented by a separate entity and used by students is still going to be on campus. So if you lease out space to the bookstore on your campus, again, that's still going to be within your campus. So ownership or control are really going to be important. Non-campus property, any building or property owned or controlled by a student organization. So a lot of times we get questions about fraternities and sororities that may be owned separately but are recognized, and how do those work? Again, you go back to ownership or control, and fraternities and sororities owned by the chapter that is on campus is considered campus property by the department. And this is part of the Clery handbook, which again is still recognized as a safe harbor, even though it's been rescinded. And I did have one question I want to answer really quickly because I don't think I'll get to it at the end. But the question was, what, in the light of the Chevron doctrine being overturned by the Supreme Court earlier, I guess that decision I think came down in July, maybe it came down at the end of June. But what do we think regarding the Department of Education's enforcement? And the answer to that is it's going to be more difficult if it's not within the law itself or within published regulations. A lot of the sub-regulatory guidance is going to be much more difficult for the department to enforce. And I think we're going to have a lot more legal challenges that occur in those areas as well. So just something to note as we were talking about the handbook. And then finally, public property. all property, thoroughfares, streets, sidewalks, public facilities that's within the campus or immediately adjacent and accessible from campus. Why it's so important is, again, it's really the bedrock principle to report all your crimes. So again, it can lead to incorrect statistics. It's important for you. We like to have our institutions, we really recommend that you have a map, that you have a list of non-campus property, that you send the list of non-campus property out to different departments. Your provost or chief academic officer should be part of this. Sometimes there will be lease agreements or agreements for space, especially if you have, which a lot of schools may have, but some are struggling with record enrollments and you don't have enough space. There may be space in which that you have your academic affairs are leasing that you don't even know about, that is going to be qualified as potentially non-campus property or other types of property. So make sure that you are appropriately identifying the guidance or identifying your property. And again, you know, we've really talked about the handbook and talking about what constitutes Clery geography. We've also have the appendix that kind of changes the geography for trips. A lot of people thought that okay, now we don't have to monitor trips. We actually were working on behalf of an institution and sent an inquiry to the help desk of the Department of Education regarding short-term trips. And the department came back and said that they are non-campus property, even if you rent them through a third party, which I was kind of surprised about. Ellen, you can add into this, but we got guidance directly from the department saying, even if you go through a third-party provider, even if you have a faculty member that rents the space themselves and asks for reimbursement, anytime that the institution itself is covering the cost of a hotel room and it's frequented by students. We also asked what does frequented by students mean, and of course the department didn't give us a clear direction, because there isn't clear direction on that. It doesn't mean one night, obviously, but you know, multiple nights, and I think, you know, over 3 or, you know, within the same year. So if you use the same hotels that your sports teams are going to, the same places, and they use the same hotels, it doesn't have to be the same people staying there. It's just the fact that you've rented that on behalf of the institution. And you can't get around it by having the other institution that you're playing against rent the facility for you, because if you do that and you don't pay for it, the other team does, they're responsible for Clery geography potentially for that as well. So somebody is responsible. So there's a lot of questions. I think, again, the appendix, a lot of people thought, oh, we can get rid of this confusing overnight stays piece of the handbook, and that doesn't seem to be the case when we've talked to the department. Is there anything you want to add, Ellen, to that discussion?
No, I would just back that up. There was a promise in the preamble to the appendix that this issue was going to be addressed. The appendix did not address it, which we have confirmed with the department. They said, yes, it did not end up there. And so they have, the folks that we talked to have continually gone back to the guidance language in the handbook, which we know is rescinded, as what they sort of use as a guide. And so we generally, when we're advising folks, rely on that too, unless we have a good reason, a good documented reason not to.
So, you know, what are the things when we see these mistakes, what can you do? First of all, I mean, make sure you're auditing your Clery geography. Don't just go, you know, we hear this all the time. And again, we adore our clients, but it doesn't get us out of issues with the department, is that, oh, this is how it's always been done. Or this is how, we don't know who decided to classify this way, but we've just been continuing to do it, and we don't want to send up any red flags to the department. It is important that you understand the difference between campus and non-campus property, between non-campus property and separate campuses. And there are a lot of separate campuses at times that people have been treating as non-campus property. So you may have to go back and make changes. And so again, you can't have a complete and accurate ASR unless your geography is correct. So, you know, these types of failures can lead to a lot of issues. And in our experience, the issues can lead to fines, number one, and then also just the department feeling like you have maybe a lack of administrative capability for understanding what the Clery Act is requiring when it comes to geography as well. So just make sure you're looking at that, and that as you are classifying these different areas, heavily rely on your statutory definitions. Go back to the law. Use the handbook as a safe harbor if there's nothing in the law that helps you, but really look at a deeper dive as to what's actually happening at those properties outside of your main campus. So questions to ask: are classes offered? What kind? Do they lead to a degree? Are there employees there? Trying to identify, is this non-campus property or is it going to be a separate campus in those areas? And determine student organization owned properties and how you're going to treat those as well. So we really say, I would have loved to tell you that you no longer have to worry about trips. Again, we got an email on Friday, I believe, from the department on behalf of an institution that says that is not how the department is interpreting the trips. Now, going back to that question I got before, a lot of the information regarding trips comes from the Clery handbook, which, as I said before, was sub-regulatory guidance, and has been interpreted by the department. So, there are legal arguments to make, but a lot of people don't want to be in that position, as well as that, they're going through these steps. They want to be in compliance. And so the department has interpreted athletic trips, at times study abroad. And again, if you own or control the campuses, you're going to maybe have separate campuses that are overseas as well. So really looking at that ownership and control and whether you have specific agreements. Okay. I think, again, I've talked too long as usual, so I think this is my last slide before I will turn it over to you, Ellen, and that is just make sure that you document. That is the best thing that we can do, especially if you haven't been through a Clery review in a while, that you're documenting your geography, you're documenting why you made decisions, and it's really helpful too if you have transition within your offices. We've heard that a lot. Oh, the person that used to handle it has now left and has moved on, and we're not exactly sure what they were thinking at the time because there's no documentation. So having documentation, having files are really important. So with that, Ellen, I'm sorry I've taken so much time, but I'm going to turn it over to you to talk about the annual security report.
Thanks, Haley. Okay, I don't know, some of you I have worked with before, and you will know that the annual security report is near and dear to my heart. So I'm eager to talk about it. We're going to start with a poll question. So XYZ University decided that the ASR was way too long and cumbersome. So they decided they were going to make it more readable by providing a link to the university's Title IX policy instead of spelling out its relevant provisions. They were going to provide a link to the description of drug and alcohol abuse education programs instead of describing in the ASR, and they were going to include only statistics from the previous calendar year and refer the reader to previous ASRs for prior years. Will the resulting ASR be compliant with the law? Yes, because all the information is accessible. No, all the information needs to be included in the ASR and not linked, along with 3 years of statistics. No, only the Title IX policy can be linked, and the institution needs to include 3 years of statistics. Or no, only the drug and alcohol policy description can be linked, and the institution needs to include all 3 years of statistics. So I'm going to give folks a few seconds to answer this. Some of you might find that the answer to this question is not the most logical answer, but it is the answer we've got. So I'll see what people think. I'm going to give people 5 more seconds. Okay, now I'm going to see what people say. Excuse me. The correct answer is actually number 4, bullet point 4. It's a funny mix. Your drug and alcohol education program information can be linked in your ASR and not explicitly included in your ASR. That is the only policy information that can be linked instead of spelled out. I should say you can use links for other things, but it needs to be in addition to hitting all the compliance points in the ASR itself. And 3 years of statistics is required. All of this can make for a little bit of a cumbersome ASR, but that's what the requirements say. So annually, the Clery regulation requires that institutions prepare an ASR, and it's got to be submitted no later than October 1st, or published, not submitted, published on your website or however you choose to publish it. And it must include a variety of policy statements and programming information, as well as crime statistics. As I said, this can be sometimes tedious, but it's part of what we do. So some common mistakes that we see when it comes to the annual security report are failure to publish it by October 1st. That's a big no-no. Even if you think there are going to be changes, go ahead and get something published by October 1st. And failure to publish it as one document. You shouldn't be referring people to a variety of documents in order to hit all the compliance points. It needs to be in one document. Accidentally leaving out various policy statements, like not discussing your relationship with local law enforcement, even if you don't have it memorialized. Not discussing security measures and the maintenance of facilities. Sometimes people will say, you know, here are how we keep our buildings secure, but they don't talk about maintenance. That is a separate policy statement. Omitting a statement about where people can find registered sex offender information. That should just be one sentence, but sometimes it kind of falls through the cracks. We see, and people just forget to include it. Not addressing confidential reporting options and the roles of pastoral and professional counselors. Some schools will say, well, we don't have pastoral counselors. That doesn't matter. You need to say that explicitly in your ASR. Failing to include information about monitoring criminal activity at off-campus locations of registered student organizations. Omitting the required statement about providing upon a written request the results of a disciplinary proceeding to the alleged victim. And then another is not including relevant drug and alcohol policy information. There are certain policy statements that need to appear in your ASR, enforcement statements that need to appear that feel very strange to say, which one of them is, you know, our institution enforces state and federal drug laws. That's a puzzling statement to make, but it's a required statement in your ASR. And then a link, you need to provide a link, or you can spell it out in your ASR, but you can also provide a link to your drug and alcohol abuse education programs. This is an area where it can get a little tricky, because when we review people's ASRs, sometimes we'll click these links and the links won't have the required information. And that is an area where the Department of Education can get you as part of a Clery audit. So make sure that the link in your ASR takes the reader or the user to relevant, current, and functioning information. You don't want dead links or wrong links in your ASR. If your campus has campus housing, you need to be sure to include information regarding missing students, and as well as a fire safety report. And then again, a mistake that we often see is relying on links when you should be spelling out the policy information in your actual ASR. I'm seeing a question. Someone has said, should any part of Title IX be included in the ASR? I think the question is should your policy be included? We're going to talk about that later on. About generally, we say the whole policy shouldn't be included, but you do need to include your procedures for disciplinary action for allegations of dating violence, domestic violence, sexual assault, and stalking. So we'll talk about that a little more later, but I just wanted to get to that question. We generally don't recommend cutting and pasting entire policies into the ASR. That's something we've seen a lot of folks do with regard to their Title IX policy. We do not recommend doing that. It is not technically wrong. We find, though, that it can be over-inclusive sometimes, which leads to a bulky ASR. It can also sometimes be under-inclusive, which is a violation if it doesn't hit all the required policy statements. We see that people sometimes fail to describe their procedures for timely warnings and emergency notifications, and then they fail to distinguish between those two types of alerts. And so that's something we're going to be talking about a little bit later in this presentation. A big area where we see folks struggle is crime statistics. People use old definitions, the non-forcible versus forcible sex offenses. They don't differentiate between arrests and referrals. They don't address hate crimes or unfounded crimes. They include only recent statistics. They don't include columns for each type of Clery geography. So you need to have separate columns for each. You need to be sure that you're dually reporting campus student housing statistics with your on-campus statistics. You need to be properly applying the hierarchy rule, which I know is very, very confusing because the FBI is getting rid of the hierarchy rule, but because the hierarchy rule is expressly mentioned in the Clery regulations, it needs to be included in your Clery statistics. And using zeros when NA not applicable would be appropriate. We see schools sometimes, if they don't have, for example, any non-campus property, they'll include a column for non-campus property and include it with zeros when they should be saying it's not applicable to them. It creates confusion if you use a zero because it sounds like you have that property and there were no crimes. So we have some compliance tips that we recommend when you're creating your ASR. One is start earlier than, September 15th to start getting this information together, including contacting your local law enforcement. This is almost something, this should be ongoing throughout the year and not thought of as a discrete once a year compliance point. You should be thinking about this all year long. And Haley talked about this. We talked about the issue of silos with Clery geography. The same issue applies to the ASR. Don't let the ASR be the responsibility of only one person. That is never going to be effective. Consider creating a committee for Clery compliance generally and for your ASR, and task each stakeholder with drafting or at least review of the relevant sections. Create a checklist to ensure that each compliance point has been addressed. Address your policy statements, all the required policy statements, even if it means saying that you don't have something. It's okay to say we don't have a policy that tells our pastoral counselors to do X. You just have to acknowledge the compliance point. We don't have a memorandum of understanding with local law enforcement. That's perfectly appropriate. Only use links where it's appropriate to do so, which is the drug and alcohol the drug and alcohol education programming. And then triple, quadruple check your crime statistics. Ensure that you've got all the proper columns. Make sure that your housing statistics your on-campus housing statistics are duly reported. And a quick check of that is your campus housing statistics should never be higher than your on-campus statistics. That is impossible, so that should not happen. Verify disciplinary referral information with your student conduct office. Make sure that what is reported in your ASR is consistent with what is reported to the department in your annual department notification. This is an area we've seen lots of people struggle, and it's particularly significant because it's an easy way for the department to look for inconsistencies. So just keep that in mind. And then ensure that your campus police, if you have a campus police department, and your Title IX office share relevant information appropriately. Sometimes we see hangups there because of confidentiality concerns. The information shared to be reported in your statistics does not need to be personally identifiable. So there are ways to get around confidentiality concerns and still appropriately report your statistics. Have the document checked by multiple stakeholders. Have each stakeholder sign off on their portion, and consider having an attorney review the final ASR. That's something we do for a lot of our clients, and it's part of our Clery Compliance Toolkit package as well. So now we're going to switch gears a little bit and talk about the daily crime log. This is only applicable for our institutions that have campus security departments. So we're going to start out with a poll question. University maintains its crime log online so that it's publicly accessible for the most recent 60-day period. On a Saturday afternoon in November, the University Police Department receives a request for the daily crime log from the previous January, so 10 months before. Those records have been archived. How should the university respond? One, it should say that only 60 days are required to be accessible, so the request is denied. Two, the university should inform the requester that it will take several weeks to gather the information and the costs will be extensive, and then let the requester decide if it wants to move forward. The university should provide the requested information on Monday afternoon because the university has 48 hours to provide the information, or the university should provide the requested information on Tuesday because the university has 2 business days to provide the information. I'm going to give you all a very short amount of time to respond because we're running out of time and I want to be able to cover our material. So the correct answer is the Tuesday afternoon. 73% of you got it. The standard is you have 2 business days to respond to a request for your archived, well, your older than 60-day information and your daily crime log. So the daily crime log must be kept. It must include, if you've got a campus police or security department, it needs to include information about the crime, the disposition. Entries must be made within 2 business days, and the last 60 days must be publicly available, and earlier information must be made available within 2 days. Issues we see: failure to make it publicly available, failure to provide the older information, failure to update the information within 2 business days. That's important. That can be an issue when it comes to the disposition of certain crimes, because you might not know it when it's first entered into the crime log, but once that information becomes available, it needs to be entered. Including only Clery crimes, the daily crime log should include all crimes, not just Clery crimes. That said, it should not be a catch-all for all campus incidents. So things that are not crimes should not be included in the crime log. Also, we have seen the department really frown on generic crime descriptions like administrative info or consultation. That is not enough information to inform the public. So what are some compliance tips? Use a standard format that includes columns for all the requisite information. Train the employees who maintain the daily crime log. Ensure that the employee has the requisite authority to obtain the necessary information, and conduct periodic reviews of the daily crime log by someone other than the primarily responsible employee. Timely warnings and emergency notifications are another area where we see some issues. Timely warnings are required for Clery crimes reported to CSAs or the police and considered to represent a threat to students and employees. Emergency notifications are required if there's an immediate threat to the health or safety of students or employees occurring on campus. The issues we see are failure to issue alerts at all, or failure to issue them in a timely fashion. Misidentifying the type of alert that's being issued, or not alerting the appropriate segment of the community. Issuing too many alerts, meaning you issue an alert every time there's a snow day or a late start or anything, and that dilutes the sort of importance of your alerts, and not following your policy. We really recommend that more than one employee be able to determine when a timely warning or emergency notification should be issued, and that more than one person have the ability to issue them, because it can happen on a dime. And so you need to be very careful that you don't lose time because someone is not around to help you send out the alert. We recommend a flow chart and following your policy. And the most important thing of all is, if you decide to issue or not to issue a timely warning or an emergency notification, document your decision making. So now I'm going to turn it over to Peter, who is going to briskly walk us through the elements of VAWA in the Clery Act. It looked like Haley might be about to say something. If she is, I will let her do that. Otherwise, I'll turn it over to Peter.
Yeah, let's turn it over to Peter. I think, unfortunately, you and I have talked a lot. So Peter, why don't you take about 3 or 4 minutes and just generally, talk about the highlights of VAWA and what we see. We definitely want to get to some of the, the
compliance tips.
Yeah. Yep, exactly. All right. Thanks, Peter.
Yeah, thank you so much. So I'm just going to skip the little poll question we have. I'm sure you guys would have all gotten it correct. But so the Violence Against Women Reauthorization Act of 2013, substantial amendments to the Clery Act that need to be included in your compliance efforts. Basically, they deal with 4 crimes: domestic violence, dating violence, sexual assault, and stalking. I'm just going to refer to these from now on as VAWA crimes. And in the interest of time, we're going to skip the next few slides with the specific definitions for these crimes, but all this is going to be available in your program materials. Okay. So your institution has several main duties regarding VAWA crimes. First, they need to be reported in your ASR into the Department of Education. A major point there is that VAWA crimes need to be reported even if the victim is not identified personally and even if there's no investigation. There is a way to unfound reports, but this has specific requirements, and the number of unfounded reports will still have to be reported. A bonus tip here is that when you're reporting instances of stalking, a separate instance should be reported for each year that an activity within the course of conduct is reported in. So here's a broad overview of the VAWA requirements in the ASR. These requirements include a description of your organization's programs and campaigns to promote the awareness of VAWA crimes and educate the community regarding the prevention of these crimes. They also require things like the steps victims should follow if a VAWA crime has occurred and the various procedures that are available for dealing with misconduct regarding VAWA crimes. So when we talk about programs to prevent VAWA crimes, this is essentially what we mean, just programs and strategies that are intended to end VAWA crimes. They have to be culturally relevant, inclusive, and sustainable. And it's also important that they be responsive to the specific needs of your community. For instance, if your community has a specific problem with one type of VAWA crime, it may be a good idea to tailor your programs a bit more toward that. They should also be informed by research and assessed for value, effectiveness, or outcome. Note that it says or. So even if the program you want to implement hasn't been researched, if it has been assessed in one of those other ways, it can still be used. And so just the programs we mentioned fall into 2 main categories: the primary prevention and awareness programs and the ongoing programs. The definitions are up there, but the main difference is that the primary ones are given to all new students and employees that join the institution. Even people who come in at uncommon times, like midway through the semester, you need to make sure that they're given the primary programs. The ongoing programs, on the other hand, are sustained over time throughout the whole year. So what do we put in the ASR regarding these prevention and awareness programs? You have to have a statement describing your primary and your ongoing programs. You have to have a statement that your institution prohibits VAWA crimes, and you have to provide the definitions for VAWA crimes in your jurisdiction and the definition of consent in your jurisdiction, along with a lot more information. Do you want me to just turn it back over to Ellen now? I want to make sure we have enough time. Ellen, do you want to take it from here?
Sure. Thank you, Peter. I'll take it from here. So Peter talked to you all about, risk reduction. And like he said, this information will be in all of your program packet. So you'll have this information about some ideas for risk reduction, some ideas for bystander intervention. These are all components of the primary and ongoing training education requirements for your campus community, which includes for students and faculty, or I should say students and all employees. Pierre has provided some ideas for prevention and awareness program here that you might find helpful. And these are some compliance requirements that are included in the ASR that are also included for VAWA compliance. Generally, you must make accommodations as requested if they are reasonable. That some of the accommodations can be, changes in your schedule, transportation, things like that. Various services must be made available, or the information about the services that are available in the community need to be included. Including ones that we often see skipped are visa and immigration assistance, and student financial aid information. There are procedures that need to be followed if a VAWA crime has occurred, and those need to be spelled out in your ASR. You also need to include in your ASR the procedures for institutional disciplinary action. This goes back to the question that someone asked about your Title IX policy and if it has to be included in the ASR. The standard is that you have to include in your ASR each type of disciplinary proceeding used by the institution to address allegations of dating violence, domestic violence, sexual assault, or stalking. For some people, that's going to be their Title IX policy. For some people, it'll be their Title IX policy and perhaps the faculty handbook or the student handbook or some other kind of policy. You need to include the standard of evidence. You need to include all of the potential sanctions for those crimes and a range of the protective measures. There's a difference there. Notice for the sanctions, it has to be all of them. That's something we see that people miss a lot. The procedures must be fair, prompt, no bias, conducted by trained officials. Then there are some other procedural requirements about the processes that I'm going to blow by, but you will have some common mistakes that we see, not explicitly stating that the institution prohibits the VAWA crimes, not including the relevant state law definitions of the VAWA crimes. That can be tricky. Failing to define consent in the relevant jurisdiction, distinguishing between your primary and your ongoing programming in your ASR. It needs to be two different types of programming that are described, not including information about protective orders or similar orders. Forgetting to state that the victims may be assisted in reporting by campus authorities or may decline to notify such authorities. Providing information, like I said, about visa and immigration services and financial aid assistance. Failing to include all the relevant disciplinary procedures. Often schools will just include their Title IX process, and that might not be enough. Cutting and pasting the policy, which we've talked about, is not technically wrong, but it might be over or under inclusive, not including all the possible sanctions. So what do we think people should do to comply? Pick the low-hanging fruit. There are certain statements that are required in your ASR. Just include those. Say, the institution prohibits dating violence, domestic violence, sexual assault, and stalking. Contact various stakeholders at the institution to obtain information regarding the relevant programming. Reach out to your Title IX office. Reach out to student conduct. All those kinds of things to determine what kinds of programming, VAWA programming your institution has, and then include that in your ASR. Keep a working document of relevant state law definitions and task someone with updating it every year. That way, you're not scrambling at the last minute to make sure that the state law definitions in your ASR are current. Don't copy and paste your Title IX policy if you can avoid it. Make sure you include procedures for all applicable disciplinary actions. Have the relevant stakeholders review this section of the ASR for consistency and accuracy.
So Ellen, before we get into kind of resources, let's just kind of add, we have 1 minute left. So let's add our biggest tips and takeaways too, which are that I think, when you were talking about the state law definitions, if your state, and Peter was going to cover this, I think we hurried him along a little too much, but if your state doesn't have a particular definition, you need to state that and still include the Clery definition in those as well. And so I think that's important. Also, a lot of these policy statements, sometimes you don't have that particular policy statement, especially if it's a separate campus, they might be smaller or things like that. You still have to include, we don't have this. You can't just leave it silent. That is a big issue. And then the other one, regarding Title IX and what's going on right now with Title IX is to really understand that whatever policy is in place as of your publication date of October 1st is what is to be included in the ASR. So I just wanted to give you that tip as well, because if you are a state, and who knows what's going to happen in the next couple days, that the Title IX regulations have not been enjoined in that particular state, and you are putting forth a new policy on August 1st, then you would need to include that new policy and new policy language in your ASR published on or before October 1st. So remember, it is your current policy with all of the policy statements, not just Title IX or other policy statements. So as you think about those, I just wanted to add those additional tips with the 30 seconds we had remaining. So thanks for letting me jump in.
All right, this last slide is a resource that Husch Blackwell offers called the Clery Compliance Toolset. One of the best things about it is it does include the state laws for each state. If your campus has locations in more than one state, that you need to have the state laws for all the states where you have a campus. So this is some information about our toolkit. Feel free to scan the code and get a determination. And with that, I'm going to wrap up. Thank you for joining us today. We hope that this information was helpful to you and your organization. As a reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. As Haley said, we use the feedback to plan future programs that are applicable for your business needs. This concludes our webinar. Thank you all so much.